Okay, this is then the third part, and I am on page 28, Professional Codes for Legal Practitioners. Okay, then you can read page 28. You will see that there's different codes for the different professions. The suspension of an advocate, there's an example of Johan van den Berg. I go to page 31. Once again, every exam paper have more or less half straightforward questions. Like, what is the difference between a profession and an ordinary job? These are straightforward questions. The fit and proper person is a thinking question where you have to combine things. But on page 31 is another straightforward question. So it's either right or wrong. There's no much interpretation. What is the function of a code? Professional codes, and you will see there's 7 bullets. So you must be able to give it like that, and you will get the marks. You don't have to think, to interpret, to elaborate. You just give it as it is on page 31. Bottom of page 31, the canons, the ethical considerations, the disciplinary rules. You can read through that and keep it in the back of your head. Page 32. That is also a question that has been asked previously. You will see it. Usually 10 marks, 5. What is the insider criticism or the outsider criticism? That is now concerning an ethical code. The insider criticism means the attorneys and advocates themselves. What is their criticism against their own code of ethics? And then the outsider criticism is, what is the criticism from the public towards these codes for the different professions? That has been asked previously. Page 33 at the bottom. The core values of a good lawyer. This has been asked so many times, and I hate this question because it is answered terribly. Terribly. It can be asked for 20 to 30 marks. And it is basically 3 subheadings: honesty and trustworthiness, good judgment, and objectivity. But, and that is where people fail. If you read through it, it makes perfect sense. But if you go into an exam scenario and you have to sit down and now give it back to me, sort of for 30 marks, students struggle. Then they cannot explain what is honesty, what is good judgment. So go through your study guide and work out an answer to answer that. Honesty and trustworthiness, the first paragraph, for example, you can start with this. Integrity, we understand reliability. Honesty, the ability to withstand the temptation to do something irregular or dishonest for personal gain. And I want to tell you an example here, and it seems obvious, but the other day I heard this story over the radio. The principal called the father and said, "You must come to my office, please, your child did something terrible." So he went to the principal's office and he said, "What did my child do?" And he said, "Your child stole his friend's pens." And the father said, "My son, why did you do it?" And he said, "But I do not have a red pen and a yellow pen and a purple pen." And the father looked at him and said, "Why didn't you ask me? I could have brought it from my work." Can you see how fine the line is between integrity, honesty, dishonesty, trustworthiness? He didn't even realize, but that is the society that we live in. Okay, so remember, even if you give an example like that to explain what is honesty and trustworthiness. Now on page 34, and this one nearly killed us. This was asked last year, first semester. We usually have a pass rate of 79%, and we went down to, I think, 39. Because page 30, is it 34? Where am my glasses? 34 was asked. And the students didn't want to answer that, and they answered Mandela, Mandela, Mandela. People, be careful. Mandela was unethical only in a political scenario. Mandela was not a bad person per se. But these people, Fine, Swain, Fassen, and in the previous semester the assignment was on Ketsikele and the road accident fund. So we asked, discuss 4 unethical lawyers that were struck off the roll, and the people answered Krauss and Mandela and Makubela, and they got naught. Why? Because we did not ask them in a political context. These people on page 34 are just plain unethical. It has nothing to do with political pressure, with fighting against apartheid, nothing. They stole trust money, they forged a signature. These are just unethical behavior of lawyers generally. So if we ask you to discuss 3 or 4 cases of attorneys or lawyers being struck off the roll for unethical behavior, you do not include Moseneke, Mandela, Makubela, none of them. Because what they did was in a certain political context. I want then a discussion from other normal, ordinary people out of politics. And there are 3 examples. You can then add either from your own experience or through reading through the whole guide, get another name, a Van den Berg or a Kleinhans or whatever. But these 3 must be there. So we will either discuss 3, or if we say 4, we want you to somewhere in the guide to draw in another one, but not one within a political context. Okay, so these 3, Fine, Swain, and Fassen. You must know a little bit of each of them, what they did and why they were struck off the roll, to indicate to me that they were unethical. Good judgment, you will see it's quite a long discussion. It's on page 36 and 37. You must go and summarize it for yourself to be able to give me 10 points on that. And if you refer to Kronman, the name will also give you a mark. Read through it, summarize it, and make sure you are able to answer, let's say, 10 marks on it. Then on page 38, the third one, if that question is asked as a whole of all the values of a good lawyer, you have to add objectivity, and you can see it's very short. So you can basically just say that it is that you should recognize your own disposition, preconceptions, and subjectivity. It's on page 39. Just give an explanation, how can you be objective? Okay, so I go back. This question on page 33, if it is asked like that, discuss the core values that make up the good lawyer. There are 3 subheadings. It is honesty and trustworthiness, good judgment, and objectivity. Or we can just ask that the honesty and trustworthiness. Then we will phrase the question, discuss 3 examples of unethical behavior by lawyers that were struck off the roll. And remember, if the word political is not there, stay away from those other guys. Then we want these people. Okay, so let's go on. Then I am on page 40, the lawyer's relationship with the law and the state. As I've said, this page 41 can now be part of civil disobedience, page 25. You link the 2 depending on how we ask it. Page 42, the lawyer's relationship with the client. There you've seen in previous papers, we always have one question with the 5 marks. Discuss the following, the referral rule. Then you must explain to us the referral rule. Why is there something like the referral rule that you cannot go to an advocate directly? Another question that we've asked, as I've mentioned earlier, if you're an advocate and you get a case of a child molester and it's completely against your morals or whatever, as an advocate, you never have a choice. You must accept every brief that you get unless you do not have the expertise or not the time. An attorney has a choice which clients to take and which not. So we like asking the referral role. We like asking the trust fund, that only attorneys have a trust fund and advocates doesn't have that. Then we like at the bottom of page 43 to ask, what can a client do that is not satisfied with the lawyer? They can either go and report it to the Law Society, they can institute a civil action themselves, or they can go to the bar of advocates. It's on the bottom of 43. Page 44. What happens when a client admits to an advocate? There at the top. Go and see whether you can answer that. Confidentiality in the middle of page 44. What are privileged information? Page 44. Remember that the privilege belongs to the client. It is for the client to say, you can use this information or you can talk about it, but it vests in the client. Then page 45, previous papers you will see asked many times, how does an advocate determine his or her fees? On page 45. Page 46, the lawyer's relationship with colleagues. Very short, just take note of that. Then page 47, the relationship with the court. Here we like asking, what is the duty in an ex parte application? And what we want to see is whether you understand what is an ex parte application. And this is shocking that we still have fourth year LLB students who doesn't know what is the ex parte application or the adversarial system. This is unforgivable, because this is your final year, you've done this in civil procedure, you've done this in criminal procedure. So you must know what is the duty in an ex parte application. And then, can you speak a lawyer to the media? Yes or no? It's there at the bottom of page 47. Page 48. How do you treat a witness when they are subpoenaed? Are you allowed to make defamatory statements in cross-examination? Are you allowed to call a woman a prostitute or not in court? Is there privilege in court to do that? When can you do it? Then page 49, the judges. The judges, and there we like to ask, how is a judge appointed and how can a judge be removed? Okay, then I go on to page 53. The reasons for the loss of ethical direction in the profession. It has been asked previously for 5 marks, and then some students just leave that open. People, there you can be imaginative. You can say, because everyone thinks he can drive a BMW once he opens his own chambers. All of those things, they are running after money, they are running after the status, there's fierce competition. You must be able to list 5 or more things. Why is it going in the legal fraternity as it is happening now? What is wrong with it? And it's all there on page 54. Then I come to page 56. Legal ethics is used traditionally, legal ethics as it is used traditionally, is it a contradiction in terms? And just below that, the traditional approach to legal ethics. Okay, now this is once again one of those fluffy questions, like the fit and proper, where we're going to expect you to think and apply your mind. But the traditional approach is exactly the same as the rule-based approach is exactly the same as our current legal system. Our current legal system is rule-based. And that is the traditional approach. In other words, if we ask you, is the traditional approach towards ethics in lawyers effective? Yes or no? And what would you should suggest? How can it be changed? Then you cannot discuss in the change part the rule-based again, because we are in the rule-based approach. The traditional approach is the rule-based approach. What means is that you as a lawyer, advocate or attorney have a code of ethics and you must follow that, and then you are ethical. So if we ask you how should it change, you must now discuss either utilitarianism, virtue ethics, postmodernism, or feminism. You cannot discuss rule-based again, because the traditional approach is the rule-based approach. And the person there that advocates for the rule-based approach is Markovits. So Markovits, Lewis, it's there at the bottom of page 56. Lewis's approach, traditional approach, rule-based approach are all the same thing. Okay, so you read page 56, they refer there to Lewis. And then you go over to page 57, and there we discuss the rule-based approach, because the rule-based approach is the traditional approach, is the current approach, is the approach that Lewis wants to follow. And then work out an answer of 10 to 15 marks on page 57, 58. And it basically boils down that you comply with rules and that is enough. This leads to the role differentiated behavior. So when you answer, if it counts 15 marks, the traditional approach or Lewis's approach, you have to include the role that it leads to this role-based behavior. But we can ask the role-based behavior as a separate question for 10 marks. And there is Markovits. So you must work out an answer on the role-based behavior for about 10 marks. And it basically means exactly there as you see on that picture. That you as a lawyer, the advocate or the attorney, you are seen as an actor. In other words, in your normal life, you are an elder in the church and you help the poor people and you're the nicest person. But on Monday when you go to court, you are the worst of worst. And then the question is asked, can you be such a person? Can you have different personalities? Are you just an actor? And then you go and read there, and some people say that no, at the end of the day you are what you are. So you should not just be an actor in court, but our rule-based approach that tell you to stick to the rules, to ask the 50 rand for the telephone call, they make a certain kind of person of you because they give you the guidelines, but the guidelines are not necessarily ethical. Okay, so that can be a question on its own. I'm going to stop here now again because the last part is then on philosophy.